My name is Nur Adriana Maisara binti Sapuan and my metric number is 2214420 and we are from group 16. Today, for our video presentation, we will explore one of the most famous contract law cases in history, Carlill versus Carbolic Smoke Ball Company from 1892. So this case shaped the modern understanding of unilateral contracts and enforceable public promises. During a deadly influenza outbreak in England, the Carbolic Smoke Ball Company advertised a cure. They claimed their product could prevent users from getting the flu and promised a £100 reward to anyone who used the smoke ball properly and still got sick. To prove they were serious, the company deposited £1,000 in a bank account. Mrs. Louisa Carlill followed the instruction, used the product but still got the flu. When she tried to claim the £100, the company refused, arguing that the advertisement was just sales talk, a mere puff, and not a real contract. The Court of Appeal sided with Mrs. Carlill. The judges ruled that the advertisement was a unilateral offer to the public and that Mrs. Carlill accepted it by fulfilling the terms. Her action, not words, counted as acceptance. The deposit in the bank showed that the company intended to be legally bound. This case became a foundation for understanding how advertisement can form contracts when they make clear, specific promises. Carlill versus Carbolic Smoke Ball Company is still taught in law schools today. It proves that even public advertisements can become legally binding contracts if they meet the right conditions. It is a powerful reminder that in a contract law, words and action matters.
My name is Muhammad Hakimi bin Jalal, metric number 2228159. The main legal issues in this Carlill vs. Carbolic Smoke Ball Co. 1892 case was whether there was a legally binding contract between Mrs. Carlill and the Carbolic Smoke Ball Company. The dispute arose when the company refused to pay her the £100 reward after she followed the instruction in the advertisement and still caught influenza. The point of law in disputes between the parties include whether the advertisement was an offer or just a sales wish promotional statement not meant to create legal obligation. Next, whether there was consideration, which means whether Mrs. Carlill gave something of value in return for the promises. Lastly, whether the company had the intention to create legal relations when making the advertisement. The area of law involved in this case is contract of law, specifically in the formation of a contract which covering the element of offer and acceptance, considerations, and intention to create legal relations.
Hi, Assalamualaikum. My name is Muhammad Farhan Hakim bin Muhammad Fazli, metric number 2226541. Moving on to the judgment of the court for this case. So the Court of Appeal ruled in favor of Mrs. Carlill and held that there was a valid and enforceable contract between her and the Carbolic Smoke Ball Company. The court ordered the company to pay her the £100 reward as promised in their advertisement. The judges agreed that the company had made a serious offer to the public and that Mrs. Carlill had fulfilled the conditions of that offer by using the smoke ball as instructed and still catching influenza. The company tried to argue that there was no contract because the terms were vague. There was no direct communication of acceptance and Mrs. Carlill gave no consideration. However, the court rejected all these arguments. The terms were clear enough. Communication was not required in a unilateral contract, and Mrs. Carlill's actions using the product as instructed were a valid form of consideration. As a result, the court concluded that the company had to fulfill its promise and pay her the reward.
My name is Naishira binti Shahril and my metric number is 2216028. Through Carlill v. Carbolic Smoke Pearl Company 1892, the judiciary reached different results due to how the advertisement read and how both parties approached their interactions. The Carbolic Smoke Pearl Company released an advertisement which offered £100 compensation to users who evaded influenza after following the instructions. The marketing material in Patrick failed to create a valid unilateral offer to the public despite of the previous requirements. The court interpreted the specific advertisement language and banned deposit of £10,000 by the company to establish a binding contractual agreement. This situation followed the unilateral contracts framework because one party made a promise to compensate another party's performance of a designated action, which served as the acceptance condition. Mrs. Carlill successfully completed the conditions of the offer because she followed the instructions despite still contracting the blue, which formed a legally enforceable contract. The legal system stated that contract acceptance through performance of a designated action rules out of necessity for acceptance communication under unilateral contract agreements. Through this case, Judge clarified details about offer and also acceptance and the need for creating legal relation as well as unilateral contracts while demonstrating the promises in specific pattern as could create binding offers.
My name is Anas bin Abdul Mudir with metric number 2214511.
From this case, there is a very big lesson that we can take. As a seller of any good or item, they should know the difference between the nature of unilateral offer and invitation to trade. It can be understood that some may confuse that advertisement is in the category of unilateral contract or in the category of invitation to trade. In this situation, the advertisement turned into unilateral contract because some condition that Carbolic put in the advertisement. When the buyer, which is Mrs. Carlill, fulfilled the condition, the contract was automatically binding. Therefore, a seller should understand how the law works and should be responsible and accountable in their act. We know that the case happened in year of 1892. However, it can be seen that this case may be relevant until this era because nowadays there are many advertisements from company or seller that is quite similar to this case. For example, register to our new workout app and lost at least 5 kilograms in 6 months. Then we will give you RM 1000. Advertisement like this may be appeared in our daily social media account, and if we join and fulfill the condition given, we have the right to claim the 1000 ringgit from the company. So we can see this kind of case always happen and the issue go viral in the social media when the seller did not fulfill the obligation. From this case, it is very important to protect the consumer that has the potential to be speculated by the sellers. The seller should show they are responsible in their promotion and advertisement by making a clear explanation so that it will not lead to misunderstanding to the buyer.